Welcome back to Criminal Law class. In today's class, let me explore another form of mens rea or mental element found in criminal offences: recklessness. Recklessness represents a lower level of fault than intention. In short, a person is reckless if they foresee a risk and decide to take it regardless. Recklessness is particularly relevant in a number of offences, such as criminal damage and common assault. For example, criminal damage can be committed intentionally and also recklessly. Section 1 of the Criminal Damage Act 1971 states, "A person who without lawful excuse destroys or damages any property belonging to another, intending to destroy or damage any such property, or being reckless as to when any such property would be destroyed or damaged, shall be guilty of an offence." The leading case on recklessness is R versus Cunningham, 1957, which established a subjective test for recklessness. The facts are the defendant's future mother-in-law told him that her neighbour was on holiday. He decided to burgle his future mother-in-law's neighbour's house during the night. The defendant ripped a gas meter from the wall in order to steal the money in the meter. Now, this caused gas to escape, which seeped through the small cracks in the wall to the neighbouring property where his future mother-in-law was sleeping. She was overcome with fumes, and he was charged under Section 23 of the Offences Against the Persons Act 1861 with unlawfully and maliciously causing a noxious thing to be administered so as thereby to endanger life. The trial judge directed the jury that malicious meant wicked. The jury convicted the defendant and he appealed. Mr. Justice Byrne in the Court of Appeal held the word malicious means either an actual intention to do the particular kind of harm that in fact was done, or recklessness as to whether such harm should occur or not. Mr. Justice Byrne defined recklessness as where the accused has foreseen that the particular kind of harm might be done and yet has gone on to take the risk of it. The defendant's conviction was therefore quashed as he did not foresee that gas would seep through the cracks of the wall so as to endanger his future mother-in-law. So in summary, Cunningham recklessness is where the defendant foresees the risk of what might occur and nevertheless carries on to take that risk. So as you can see, there are two elements that need to be shown for Cunningham recklessness. One, the defendant was aware that there was a risk that his or her conduct would cause a particular result. And two, the risk was an unreasonable one for the defendant to take. In other words, Cunningham recklessness, or subjective recklessness, as it is sometimes known, will arise if the accused consciously takes an unjustified risk. And because the test focuses on what the defendant actually foresaw, it makes the test a subjective one. Now, the House of Lords in the case of R versus G reaffirmed the subjective nature of the test for recklessness as it applies to property damage. This was a case involving two boys aged 11 and 12 who set fire to a bin outside a shop. The fire spread, causing extensive damage. Despite this, the court ruled that these two boys could not be found reckless because they had not personally foreseen the risk of the fire spreading. Lord Bingham stated in R versus G that in criminal damage cases, a person acts recklessly within the meaning of Section 1 of the Criminal Damage Act 1971 with respect to Roman numeral 1, a circumstance when he is aware of a risk that it exists or will exist, and Roman numeral 2, a result when he is aware of a risk that it will occur and it is in the circumstances known to him unreasonable to take the risk. And just to reiterate this point, as you can see from both Cunningham and R versus G, recklessness means the defendant must foresee the risk of a result, however small that risk is foreseen by the defendant. This means the defendant would not, on the face of it, be reckless, where the defendant says they carried out an assessment of the risk but concluded there was no risk of harm, or defendant says the risk of harm never crossed their mind. Alternatively, where the defendant says they thought the risk was small, or they concluded the risk was minimal or unlikely, the defendant would still be reckless. And remember, a defendant would not be reckless if they ought to have seen the risk, or a reasonable person would have foreseen the risk. And never forget this, because the test for recklessness is a subjective one. The risk must be seen by the defendant, which is ultimately decided by the magistrates or jury if the case gets to a trial. Let me now turn to explaining the difference between recklessness and indirect intention. It is essential in criminal law that law students and lawyers to distinguish between recklessness and indirect or oblique intention. Recklessness involves a defendant foreseeing a risk, whether that risk is seen as low or high, but not virtually certain, and choosing to take it. Oblique intention or indirect intention applies when a defendant appreciates that a consequence is virtually certain. To highlight the difference between recklessness and indirect intention, take the example of a young teenager kicking a ball up and down a street nearby parked cars. And the young teenager foresees that there is a risk that the ball might smash a car window, but not caring, and the car window is smashed. The teenager would be reckless. However, imagine if the teenager kicks a ball in a living room full of ornaments and damage is caused to those ornaments. The teenager may now have an indirect intention to cause criminal damage if criminal damage would be a virtual certain consequence by kicking the ball in a room full of ornaments, and the teenager appreciated damage to those ornaments would be a virtual certain consequence of his actions. To conclude, don't forget, 1. The Cunningham test for recklessness is whether the defendant foresaw a risk, subjective, of whatever is required by the specific offence and went on to take it, and the risk is an unjustified one to take, the objective part. 2. The defendant must foresee the risk, however small that risk is foreseen. And 3. The test for recklessness is a subjective test, not an objective test. In our next criminal law class, I will be looking at negligence, which differs from recklessness and intention, and to note that negligence is an objective test. Thank you for watching. Feel free to comment and don't forget to follow and subscribe for more.